Now let's see what happens about a week or so afterwards. So we know that about a week afterwards, Laura Amber Heard and her lawyers, they submitted this motion to either one, dismiss the verdict completely, two, or ask for a retrial. And then they also want an investigation into jury number 15 because they found out, although it wasn't after when the trial, they claimed that jury number 15 is not who they claimed he was. He was supposed to be born in 1945, I think, but he was really born in 1970. So that's a discrepancy of around 25 years of age, although the name was the same and the address was the same. I already went through that in a different video. We won't talk about it today, but that's just basically the recap of it. And now the thing was, Johnny Depp and his lawyers were like, "Bro, you submitted this like a week after it was due. You're like a week late." And not only that, they submitted it, I think, on the 8th. And Johnny Depp and his team, if they were to reply to any post trial motions, they would have to do so by, I think, like a July 11. So not only did team member Heard submitted their post trial motion a week late, they submitted 3 days before Johnny Depp and his lawyers were supposed to respond. So they definitely, they throw some jabs for Amber Heard and her lawyers doing that, and we'll get to that right now. So we can read. I'm not going to read the whole thing, but I do want to read some of the parts that are funny. And I wish I was able to highlight this document because I'm going to have to like look around for it. But it is pretty funny. Like I guess like when you're doing lawyerly things like this, you can make jabs at the other side. Now this is from Johnny Depp's lawyer, and again, this is a response to Amber Heard's lawyer. Okay. Following a 6-week jury trial, a jury of Ms. Heard's peers rendered a verdict against her in virtually all respects. Now, here's the jab. Though understandably displeased with the outcome of the trial, Ms. Heard has identified no legitimate basis to set aside in any respect the jury's decision. Virginia law is clear that a verdict is not to be set aside unless it is, in quotations mark, plainly wrong or without evidence to support it. Here, the verdict was well supported by the overwhelming evidence consistent with the law and should not be set aside. Mr. Depp respectfully submits that the court should deny Ms. Heard's post-trial motions on the verge, which verge into the frivolous. Like that to me, that's a dig right there. I'm like, man, I didn't know you could make digs like that. But okay, let's keep reading because it's kind of interesting. What I do want to know, I wonder if when Judge Penny makes a decision on this, is it going to be just a written explanation, or is she going to have to bring Elaine and Ben Shu into the courtroom as well? Because I wish we can get the court transcripts for that because I don't think it's going to be on TV. All right, two, the damages awarded by the jury were supported by evidence and law. So let's just go to specific examples, I guess we can do. Here it is. So this is why they said it was supported. So we're gonna go to Jack Wiggum. I like Jack Wiggum, by the way. He was in 2017, the year after Ms. Heard's public allegation of domestic abuse, but before the op-ed was published, Mr. Depp filmed multiple pictures. Oh yeah, so this was the crazy thing. So Elaine and her lawyers, they were saying that the reason why the verdict doesn't match what was testified by other people, the witnesses and all that stuff, because they never actually showed that Johnny Depp's reputation was affected by the op-ed. And I was like, man, they did such a good job at showing how affected he was, like how he was doing all these films and now he wasn't doing anything. All right, so it'll get into it right now. Mr. Depp filmed multiple pictures, including 3 studio films for which he was compensated between $8 million and $13.5 million. 2017 was a typical year for Mr. Depp. Because 2017 was busy with 3 large studio films, Mr. Depp had a specific plan in 2018 to rest half of the year and then do a tour with his band. And then he also wanted to hang out with his kids as well, which explains his absence from filming any studio movies in 2018. Then, of course, the op-ed was published in December 2018. Mr. Depp did not appear in any studio films between December 18, 2018, the date the op-ed was published, and October 2020, the date before the UK trial. In response to a question if Mr. Depp lost roles between December 2018 and October 2020, Mr. Wiggum answered, yes. After the op-ed, it was impossible to get him a studio film, which is what we normally would have focused on in that time period. Then they write, the testimony on its own fully supports the jury's $10 million verdict. And you know what? I thought he should have gotten more than 10 million, but I was glad that they ruled in his favor. But yeah, I think he should have definitely gotten more than 10 million. I thought 10 million was some small chump change, but I mean, obviously for Amber Heard, it's not. But for Johnny Depp, yes, was a reasonable verdict that could infer from this testimony that in the 22-month period after the op-ed, Mr. Depp lost one or more studio films as a result of the op-ed and the newly alleged SB allegation. So I'm gonna make all right, what is next? Now they cite this part, noting that the credibility and the weight of witnesses' testimony belongs solely to the fact finder, which is the jury. When weighing conflicting testimony, the touchstone is always credibility. The ultimate measure of testimonial worth is quality, not quantity. So it's basically saying that if the jury decides to believe this one person's testimony over the testimony of other people, it's completely fine. Because if they only want to believe their testimony, and they only find this person's testimony as credible, then it's okay that they choose their testimony over anyone else's testimony. So that's that was a really convoluted way of saying this paragraph. Anyways, with rare exceptions, jurors are free in the exercise of their honest judgment to prefer the testimony of a single witness to that of the many. All right. Now, Mr. Wiggum also testified that he negotiated an agreed upon deal for Mr. Depp to star in the sixth installment of Pirates of the Caribbean franchise for $22.5 million. And yes, there wasn't a written agreement. It was mostly a verbal agreement. What they said in Hollywood was that, usually if you're already making like 1, 2, 3, 4, 5, you're already making like prequels, sequels, or whatever the fuck, then at some point it does become like a verbal agreement. They're like, okay, yeah, we're gonna do the movie, and then later on, that's when they do like the whole written agreement. That's what they said. I don't know about Hollywood shit. I'm just going by what they say. Hi, Bleep, how are you doing today? What's going on? All right, so the producer of the film, fall of 2018, the producer of the film, Jerry Bruckheimer, really wanted Mr. Depp in that film. And that in the immediate aftermath of the op-ed being published, it became clear that Disney was going in a different direction in terms of a plan to use Mr. Depp in the sixth installment. Yeah, I thought it was directly correlated because you guys remember the op-ed came out a couple days afterwards. There's an article. The Disney head person was like, yeah, we're going to go in a different direction in regards to using Johnny Depp in Pirates 6. So I thought that was a direct correlation to me. That was like, oh yeah, the op-ed definitely shut him out of the whole Disney thing. Next, we have Michael Spindler, an expert in forensic accounting, testified that Mr. Depp suffered lost earnings of approximately $40.3 million between December 18, 2018 and November 2nd, 2020 as a result of the op-ed. So when I heard about the $40.3 million, I assumed that it was $40.3 million and then maybe the rest were just like lawyer fees that Johnny Depp had to pay. Because I was like, oh, I wonder how they got the 50 million figure. It made sense to me. However, it didn't make sense to me how Amber Heard got the 100, because she countersued for $100 million. I was like, was that just a power move to just like double the amount of Johnny? Like, like a poker move of some sort? Because I was like, how the fuck is she countersuing for $100 million? Like, what did she lose out on that was $100 million worth, But yeah, I don't know. My guess is that it's just a power move. They said that like people wanted to give him more money, but there were some people that like there was one person who had sympathy for Amber Heard, and I think that was the person that they're kind of like negotiating with. But yeah, I don't know. 10 million was a little too low for me, but I'm glad that it at least got something. It just sucks that the punitive one was reduced from 5 million to 350K. It's like, the fuck? Then what's the point of awarding 5 million if 350 was the max anyways, But yeah, whatever. So Michael Spindler says that he would have gotten $40.3 million as a result of the op-ed, 20 million in lost income from Pirate 6 and 20 million in lost income from other potential projects. In reaching this conclusion with respect to a lost income with other potential projects, Mr. Spindler utilized 2017 as a base year and extrapolated Mr. Depp's earnings over the period December 18, 2018 through October 2020. 2017 was the year after Ms. Heard's PA allegation and a typical year for Mr. Depp in terms of his workload and earnings. Mr. Depp also testified to the damages Ms. Heard's allegations in the op-ed inflicted on his career, including learning within the days that that Disney was dropping him from Pirate 6, as well as emotional distress that the statements in the op-ed had caused him. The fact that Pirate 6 had not been made certainly does not preclude a finding by the jury that, but for the op-ed, Disney would have made it with Mr. Depp, consistent with the deal Mr. Wiggum testified already in place. Yeah, this gets into how Mr. Depp was not even required to present proof of actual damages to sustain a verdict. So there's just a bunch of citations from other cases. While I think this is another jab too. Okay, this might be another jab. While Ms. Heard cites 4 Virginia cases in support of her remitter argument, each defamation case must be assessed on the specific facts on the case. And the cases cited by Ms. Heard are clearly distinguishable. So they're basically saying, Elaine and the lawyers, the case they're citing doesn't even have anything to do with Johnny Depp and Amber Heard's defamation trial. These cases are not even related because there are different specific details that are different. That was a horrible sentence. I feel like in our closing, honestly, if you guys look at my streams, I started snoozing a little bit when they were doing the closings for Elaine. I don't know. She kind of just rambled towards the end. I don't know. I was just like, well, okay, whatever. All right. They say 3 of the 4 cases are decades old and none involves an international A-list, false allegations of SA, or defamation in a nationally circulated newspaper. So now this is them shutting down Elaine's arguments. Let's start with number 1. Richmond Newspapers v. Lipscomb. The Virginia Supreme Court upheld remitter of $900,000 from the $1 million damage award to a teacher who was defamed in an article published in a local newspaper. Nothing about those facts even remotely resemble the facts in this case. Second one, or similarly, Gazette versus Harris. Supreme Court determined $100K damages to a professor who was defamed in a local newspaper was so out of proportion of the damages sustained as to be excessive as a matter of law. The court noted there was effectively no damage in that case. Mr. Depp, on the other hand, put forth substantial evidence and testimony of how he was damaged. So they're like, this case, not even relevant, Elaine. Why are you citing it? Next. Elaine points to Thomas v. Simas, noting that this case where a compensatory damage award for defamation was reduced because the plaintiff has already been unflattering portrayed in the media at the time the defamation statement was made. So remember how Amber Heard, she had her experts saying that Johnny Depp, he was already getting bad coverage in the media. So it wasn't Amber Heard that destroyed his reputation. It was him, his drug use, and all those things going on, and the articles that popped up in trash news website, People magazine and stuff like that. These were the things that were destroying his reputation, not Amber Heard. And so that's why they're citing this case. Again, the case is easily distinguishable. So they're like, yeah, it's not even relevant because Thomas, plaintiff presented no evidence of any particular loss that he suffered as a result of the defendant's statement. He offered no witnesses to tell the jury about the effect that defendant's statement had upon him. He had no witnesses. The hell? How did this case even go to trial? No one testified that they thought less of him or that his reputation had been harmed by the defendant's statement. The loss of his employment with the city of Portsmouth was not attributed to the defamation, and no prospective employer testified that a plaintiff had been denied any job opportunity because of that statement. He called no witnesses who even saw the television broadcast. All right, that trial right there sounds like a shit show. Good God. And they're saying conversely, there was substantial evidence that Johnny Depp was harmed by the defamatory statements in the op-ed. Man, it's actually because I'm not familiar with these cases and stuff like that. So when I read Elaine's motion, I was like, oh, okay, they're citing a bunch of cases, but I don't do research in other cases because it was a million things that they cited. So I'm not familiar with them. But here we have another lawyer who's like, wait a second, I'm familiar with these cases, and you guys are just taking things out of context, or you're just throwing what's that term when you throw glue at the wall and see what sticks? Is that the term? I don't know if I've been saying it right. They talk about how Mr. Depp felt sick, how there's no truth in it. They quote him. The evidence showed that Mr. Depp was actually entitled far more than the $10 million awarded. I agree with that. Fourth and finally, Ms. Heard points to Sheckler v. Virginia Broad, again arguing that the court reduced a damage award from $10 million to $1 million. So again, in Amber Heard's post-trial motion, they were like, oh, the jury awarded Depp way too much money. He even proved that he lost that much. There's no way the op-ed affected him. So this is their response to it. So they cited this case, Sheckler v. Virginia Broad, and because there were other causes of the injury sustained by the plaintiff. Again, the case is easily distinguishable. First, the jury award of $10 million in this case reflects this consideration of other potential sources of damage to Mr. Depp's reputation and career, as there are evidence supporting a much larger damage award. Secondly, the plaintiff and Sheckler worked at an auto shop. The injury to the plaintiff's business and career is simply not the same level as Mr. Depp, one of the highest paid actors in Hollywood. So I guess in that other trial, Sheckler v. Virginia Broad, the guy that worked at an auto shop, he was awarded $10 million. And then the court was like, oh, no, $10 million is way too much. Like, there's no way that you should get $10 million. So that's why they reduced it to $1 million. And Johnny Depp and his lawyers are basically saying that, like, these two aren't even comparable. This guy works in an auto shop, Meanwhile, Johnny Depp, like, he's one of the highest paid actors in Hollywood. And of course, like, him getting $10 million, it's like, it's reasonable, even though he should have gotten more money. The plaintiff in Sheckler was not entitled to presume damages, unlike Mr. Depp. Distinguishing a Virginia case where $2 million defamation award was sustained because, unlike the case at bar, the plaintiff carried the burden of proving actual malice, and therefore the plaintiff was entitled to receive presumed as well actual damages. Here's the part where Amber Heard was like, no, it wasn't the op-ed that caused him to harmed his career. It was other things. So Ms. Heard asserts that damages to Mr. Depp's career must have had other causes than the op-ed. I don't know. What else was going on in Johnny Depp's life? Like, yeah, he had some, like, negative news coverage, but what celebrity doesn't have negative news coverage, There's always, like, fodder out there that's like, oh, my God, they got drunk, and they were being rowdy, and, like, oh, my God, they presumably beat up another person. Like, there's always, like, bad publicity around, like, an actor, actress, anyone that's famous. It's like inescapable. But when someone comes out with a, SA allegation, DV allegation, those things are taken very effing seriously. I don't care if Australia doesn't win, but I hope they drag her to court and make an example. I mean, the government got money and time just to keep her in court. Listen, Rain, like, initially, I made a video about Amber Heard in Australia, and I think I was being way too fucking lenient and light on her, because I said that I didn't think she deserved jail time for the Australia perjury thing. I was like, oh yeah, I thought, maybe like 14 years jail time was like too excessive, and 14 years may be excessive, but I do think she needs to serve jail time. Before I was like, oh, I don't know if she should serve jail time. Maybe she should just be banned from coming back to Australia. Maybe she should do community service in Australia. But no, I think she should definitely just serve jail time, because when I thought about it, this is a person that has lied in 3 other court systems in 3 different countries, okay? We have the UK trial, lied. We have the US trial, lied. We have Australia, lied. 3 different countries. She needs to get punished. With the assumption, let's say we assume that she did smuggle the dogs knowingly, okay? So this is the assumption here, okay? 1, she brought the dogs to Australia, even though she was told that she didn't have to write paperwork, right? We're making that assumption. Okay, so when you bring a dog to a foreign country, right? It's like you already smuggled the dog in, and you would think that you would just keep the dog at your mansion, or where the hell they were staying. They were staying somewhere glamorous. Why the hell did you bring the dog to a local groomer's where the dog would have contact with other dogs and other people? It's like, why would you do that? Because 1, going to the groomers is not even necessity at all, okay? It's not like the dog was going to emergency vet. It was choking. It had anaphylactic shock from swallowing a bee or something like that. You took the dog to the groomer, a very unnecessary thing. So that thing bugged me, and that's why they got caught. Not only that, after they were called out by the Australian authorities, she was like making jabs at the Australian authorities. She was like making fun of them and stuff. I mean, I know like a lot of people gave them like shit for basically threatening to put their dog to sleep or shipping their dog back to the country, to the US. But it was just like she was just so laughing at their face, and like I think a year ago she made like a jab at what's his name, Barnaby, what was he, the Australian former prime minister of something? I forgot who he was. But yeah, she made like a jab at him, and she named her dog after him and posted on Instagram. So she's like still making jabs. She's still like laughing at it. But just to rewind it back a little bit, the fact that with another assumption, let's say we assume that we believe Johnny Depp, that Amber Heard threw the bottle and like damaged his tip, if we assume that that's true, I find it so weird that and making the other assumption that it was all Amber Heard's fault that she brought the dogs to the country and Johnny Depp didn't really have anything to do with it. Because I don't know. I feel like Johnny Depp doesn't really care about the logistics. He kind of just, he has like other things on his mind. He just kind of just appears and just shows up. But let's say that, like, you know, Johnny Depp also gets in trouble because of what Amber Heard did. This guy just had like a bottle thrown at him. The tip of his finger is gone. And like, you know, and then like later on, he basically has to, he has to be as much trouble as his wife who did all this. And like, he's like making this like really weird apology video for like something that like he didn't even do. You know, that's like a lot of assumptions that we're making. But like, I don't know, man. I feel like it's just a really crappy situation. Oh, this is Amber Heard asserting that Johnny Depp's career had other issues other than the op-ed. Okay. Ms. Heard also attempts to argue that the fact that the evidence was presented about the parties' historical relationship and Ms. Heard's initial allegations of abuse in somehow suggested that a jury award damages for conduct by Ms. Heard separate from the op-ed dating back to 2016. Not so. It was obviously necessary to present evidence regarding the historical relationship and allegations. So something that was mentioned in Elaine's post-motion trial was that, oh, Johnny Depp and his team, you know, in their closing argument, they talked about how this affected Johnny Depp back in 2016. Therefore, they were trying to trick the jury into thinking Johnny Depp should receive damages all the way back from 2016 to 2020. However, I didn't agree with Elaine saying that because Elaine and like the lawyers, Johnny Depp's lawyers too, they were the ones that wrote out the jury verdict form. The jury verdict form clearly says that this is the time period where Mr. Depp should be awarded money, not 2016, 17, and whatever time period. So I don't know. It was clearly a very, very weak argument in my opinion. So this is them disputing it right here. So they're saying that like, well, we had to bring up 2016 because it's showing how, you know, she's made allegations before, and we have to show they say historical relationship between the two. And then I'm going back to reading this. Since that provided necessary context for the jury to evaluate the defamatory nature of the statements in Ms. Heard's op-ed and her purpose, motives, and veracity in continuing to claim to have been A in the op-ed. But at no point did Mr. Depp request damages other than the statements in the op-ed. The jury instructions were explicit that damages were required to be caused by the defamatory statements at issue. And Ms. Heard's arguments are based on nothing other than pure speculation. All right, and they're saying the jury, they were able to assess the testimony and the evidence, and that's how they got the $10 million. This is a time period. All right, what are we arguing here? 3, the verdicts on the complaint and counterclaim are consistent. So Elaine and her attorneys were saying, well, you know, the jury, they awarded Depp all 3 counts of defamation. However, because they awarded Amber Heard 1 count of defamation, that means that their verdict is inconsistent with each other. Because how can they believe one and then still believe the other as well? So they're going to get into why it's possible to believe that Amber Heard was defamed by Adam Waldman, and at the same time believe that Amber Heard also defamed Johnny Depp. So I'm just going to go straight to the meat of this without reading all this. This is a statement that they believe. So I'm going to read the whole statement again because the argument is going to, it's basically going to pinpoint some of the stuff in the statement here. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but first attempt did not do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine, roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. So this is what Adam Waldman said. However, we also find out that there's a reason why Adam Waldman made such a specific statement. Because I don't have access to that email. Maybe you guys do. But Adam Waldman apparently had a phone chat with Drew, one of Amber Heard's key witnesses, which is also her best friend's ex-fiance. They're not together anymore. But Drew said that, yeah, you know, we kind of did this, and we sat with Amber Heard lawyer, and you know, Samantha Spector was like talking to us for an hour and telling us to get our story straight and to call the cops and all that stuff. So, initially when we found out about this, it does sound like this is something that was defamatory. But then later on, we found out that, Adam Waldman believed this because Josh Drew basically told him. All right. As it is clear from even a cursory review of Mr. Waldman's words, there are multiple, highly specific, and detailed factual elements to the statement that the jury could determine were false while still concluding that the abuse allegation by Ms. Heard about Mr. Depp were false and defamatory. For example, the jury could have determined that Ms. Heard lied about the A, but then she and her friends did not spill a little bit of wine, rough the place up, in an attempt to make a false police report on May 21st, 2016. And that's what I believe too. I think the jury did not believe about her being A by Johnny Depp. It's possible that they just didn't believe like the whole they set up the whole messing up the apartment thing. Of course, such a finding on the sole counterclaim is not consistent at all, much less irreconcilable with the jury's verdict on the 5 other statements at issue, where the jury clearly determined that Mr. Depp did not P or S.A. Ms. Heard. If anything, the jury's conclusions show with care with which the jury analyzed each of the statements and that Ms. Heard's claims were considered fairly and seriously. The verdict should stand. Judge Penny is going to make a decision on all of this. And I feel like when she was reading, I don't know, I could just see Judge Penny just like shaking her head like, oh God, what the fuck? I'm too busy for this, man. It's summertime. All right, 4. The First Amendment does not bar recovery for defamation. So again, Amber Heard and her lawyers, they make that argument. Well, Amber Heard should be covered by the First Amendment. She's allowed to talk about this. And so again, this was already covered in the fucking trial. It's like, why are we addressing this all over again? But Johnny Depp and his lawyers were like, bro, she's not covered by First Amendment. Let me see if I can just get to... here it is. Okay, we'll just read the beginning. The court has repeatedly held that Ms. Heard's statements in the op-ed are sufficient to support a claim of defamation by implication, and Ms. Heard presents no arguments in her motion that would justify a reversal of those rulings at this stage. Indeed, Ms. Heard egregiously and flagrantly misrepresents Virginia law in arguing that the Virginia Supreme Court has signaled defamation by implication may not be applicable when it involves a public figure or matters of public concern. The Virginia Supreme Court has made no such suggestion, and the out-of-context language relied on Ms. Heard is misleading. So they're like, bro, she's just like, not her, but her lawyers are just literally just... they're taking little things out of context and they're trying to use it to support their argument. And then Johnny Depp's lawyers are like, nah, man, it don't work like that. Virginia Supreme Court rejected that argument, stating a defamatory innuendo is no more protected by the First Amendment than is defamatory speech expressed by any other means. Let me just read some highlights. Critically, the Fourth Circuit recognized that even in the case involving public figures and matters of public concern, there could still be defamation by implication. So yeah, they're basically saying that like you can't just defame people even if they're public figures as well. And the fact that they cited this case incorrectly, and here's them like correcting it. The Pendleton Court recognized explicitly that because of defamatory speech falls outside the protection of the First Amendment, a First Amendment analysis is inapposite, which is like, what's that word? Inappropriate, I guess? It's like a fancy word for saying inappropriate. In a case in which a plaintiff must allege and ultimately prove that the defendant intended his words to express a defamatory innuendo, that the words actually did so, and that the plaintiff were actually defamed thereby. There's no suggestion that the First Amendment might protect defamatory speech if the speech involves a public figure or matter of public concern. Clearly, public figures should be allowed to seek legal redress based on a theory of defamation by implication, just like anyone else. Because, if that was true, that would mean that, hi, Tam Jules, that would mean that anyone can just write a defamatory article about any public figure and not suffer from the ramifications from it. Indeed, many other jurisdictions have recognized the sound policy of defamation by implication is permissible for public figures. Here are some citations. I do like this quote right here, I think. To deny a public official the opportunity to demonstrate the defamatory innuendo of publication, even one critical of governmental conduct, is to open Pandora's box from which countless evils may spring. A legal fiction denying the existence of clearly discernible, though not explicit charges, exposes public officials to baseless accusation and public mistrust, while promoting an undisciplined brand of journalism, both unproductive to society and, as we see it, unprotected by constitutional considerations. So this is again just reinforcing the idea that you can't just defame a public figure. So I like that quote right there, and I think we can just skip all this part. I think. Oh, we can talk about the ACLU thing. Okay. As the testimony and evidence of the ACLU, corporate representative in this case showed, Ms. Heard made a very calculated effort in crafting the language of the op-ed to try to avoid any explicit defamatory reference to Mr. Depp, while clearly referencing him implicitly. I don't know. I still think it's so crazy. Like the arguments that they're making. So they're like saying, oh, the op-ed didn't damage Johnny Depp's reputation. Johnny Depp wouldn't have gotten Pirate 6. Johnny Depp shouldn't have been awarded $10 million. That's way too much. Johnny Depp, he wasn't even named in the op-ed. Like these are arguments that have been reiterated so many times already, but they've already have been shut down. We've already addressed all of this. It's just so crazy how they're still, it's like a broken record. They're still repeating the same thing over and over again. It's like, hello, we all listen to, or I mean, most of us, but we listened to the ACLU guys like testimony. He clearly said that, yeah, it was about Johnny Depp, but we just couldn't mention him because, Amber Heard's lawyer, they have this Amber Heard and her lawyers, they have this contract that they have to follow by, and they have to make sure that they don't name Johnny Depp and stuff like that. But it clearly referenced him because it says 2 years ago. And what happened 2 years ago when she got the TRO and stuff. So it's just so crazy how they can still be like, oh yeah, he wasn't named. We're not talking about him. Anyways, so they said that Amber Heard should not be able to skirt the liability stemming from the devastating impact of her op-ed simply by carefully choosing her words so as to convey a defamatory meaning about Mr. Depp, but without actually using his name. Such a result would manifest unjust and has no support in Virginia law. Simply put, the Virginia law, Supreme Court of Virginia has never held or hinted that defamation by implication does not apply to public figures or matters of concern. All right. Jury's finding of defamation regarding the op-ed headline. Yeah, so they're still saying that the headline, she's not responsible for the headline because the headline was something else. But here's the thing, though. The fact that she retweeted it and the headline was in her tweet and she even commented in her own tweet, there's no way that she didn't see it. I think that's what she claimed. She's like, oh, I didn't see the headline. I didn't notice that they changed it. No, I'm pretty sure you saw the headline, okay? Because you're getting so much publicity. You're probably glowing in your limelight right now. You're like, oh my God, oh, this is what they wrote in the headline. There's no way you didn't read the headline. I just don't believe it. Hi, Gina. How are you doing today? How's it going, Gina? Under the republication rule, one who repeats a defamatory statement is as liable as the original defamer. Okay, that's a quote right there. In the context of internet articles, other courts held that a statement on a website is not republished unless the statement itself is substantively altered or added to, or the website is directed to a new audience. And I do agree, it was directed to a new audience. It's going to explain why, but it was a Washington Post article, so there's Washington Post readers. 2, it was posted on her Twitter. Her followers, it gets retweeted, blah, blah, blah. That is completely a whole new audience right there. While some of them might read Washington Post, yes, but I'm sure that there are a lot of people on Twitter that probably don't read the Washington Post. So definitely add it to a new audience. One general rule is that the statement is republished when it is repeated or recirculated to a new audience, and holding a statement on a website is not republished unless the statement itself is substantively added or altered, or the website is directed to a new audience. So not only did she just retweet it, she retweeted it, and then she also wrote something in the retweet. So that got her in trouble too. Typically, the single publication rule is invoked by Ms. Heard is a rule designed to limit the number of actions that can be maintained for a statement by the same defamer. The purpose of the rule is to prevent endless re-triggering of the statute of limitations. It does not provide a safe haven for a different defamer to republish a statement without consequences. Here, the evidence shows that Ms. Heard tweeted a link to the online version of the op-ed, including the title, which was prominently displayed. Prominently displayed. In that tweet, she proudly declared, in quotations mark, Today, I published this op-ed in the Washington Post, ... Nowhere in her tweet or anywhere else does she disavow that title. Instead, she adopted it, in quotation marks. One who repeats a defamatory statement is as liable as the original defamer. If that is not affirmatively reiterating the statement, it is hard to imagine what is. Ms. Heard continued, noting in the tweet that the article was about women who were channeling their rage about violence and equality into political strength despite the price of coming forward. From college campuses to Congress, we're balancing the scales. I mean, I would say she was trying to achieve multiple things in that article. So just because she was addressing this aspect of the article doesn't mean she was still talking shit about Johnny Depp and throwing him onto the bus. She could still do both. This is a substantive addition, I hate that word, to the text of the article, and it further implies that Ms. Heard was a victim of a defamatory assertion the jury soundly rejected. Moreover, she replied to her own tweet on the same day stating, I'm honored to... so she replied to her own tweet right here. I'm honored to announce my role as the ACLU ambassador on women's rights. Is she still an ACLU ambassador? These substantive and defamatory additions are sufficient to constitute republication of the op-ed. Oh, is she still ACLU ambassador? All right. Further confirming Ms. Heard's republication of the op-ed is that she directed it to a new audience. Ms. Heard's tweet went out to hundreds of millions of Twitter users to see, including her hundreds of thousands of direct Twitter followers. There's no question that the readers of the Washington Post online, where the op-ed was posted, are a decidedly different audience than the millions of people using Twitter. That distinction is important when looking at cases cited by Ms. Heard in argument. Oh yeah, I thought this was funny too. So they cited this case right here. They're like, oh yeah, Lakova versus Halper. Yeah. In that trial, yeah, they in that trial, it didn't count as republication. That applies in my situation too. But Johnny Depp's lawyers were like, bitch, it's not even the same thing. So let's find out why. In that case, in determining that there was no republication, the Fourth Circuit relied on the fact the New York Times article at issue was hyperlinked in a subsequent New York Times article. Thus, the hyperlink served as a reference for the New York Times existing reference and did not direct the old article to a new audience. So they're saying that this doesn't count as republication because the link that had a defamatory whatever was already a link in a New York Times article. So they're saying that doesn't count as republication. And Amber Heard and her lawyers were like, oh yeah, that's the same thing as us. It doesn't count as republication. Nah, Johnny Depp's lawyers like, no, dipshit. It's different because in your situation, you took the Washington Post article and you tweeted into a whole different website, a whole different social media platform on your Twitter. So that's why they're saying it's not the same thing. That is not the case here, where Ms. Heard's Twitter followers and Twitter users in general are different audiences than readers of the Washington Post online. While Ms. Heard cites to a non-binding case law in other jurisdictions stating that a hyperlink may call the existence of the article to the attention of a new audience, it does not present defamatory contents of the article to the audience, and thus is not republication. Ms. Heard adopted the statement as her own, affirmatively reiterated the statement, substantively added to the statement, and disseminated the statement to a new audience. Ms. Heard adopted and republished the statement in every sense of the law. The jury was fully justified in its finding Ms. Heard liable for the headline. What is this? 6. The jury's finding of actual malice is well supported in the record. I don't know if we need to get into this one. So it's just basically saying that, there was malice behind it. I think we can skip this part. They talk about TMZ, how they knew where to show up at the courthouse, where to stand, where to take pictures of her face. Ms. Heard's argument that the element of malice has somehow not been established are utterly meritless, misleading, and amount to nothing more than an improper request for the court to substitute its judgment for that of the jury. I wonder how often the court does that. Because I feel like for the most part, the court doesn't want to step over the toes of the jury, because it's like, well, what's the point of having them serve on jury duty if the court is going to continually just overrule what the jury's already decided? The cursing doesn't bother me. I grew up with South Park, Beavis and Butthead, and yeah, that was my childhood right there. So that could probably explain why there's a lot of cursing and a lot of potty humor out of my mouth. 7. Mr. Depp presented sufficient evidence to support a finding of defamation by innuendo. What is this part right here? In her desperate attempt to justify the extreme remedy of setting aside the jury's carefully considered determinations, which were fully supported by the overwhelming credible evidence. Ms. Heard presents a tortured. Who wrote this? This person is like so funny. Are you allowed to throw jabs like this? Is that professional? I love it though. It's like, oh, it just adds more to the drama. Ms. Heard presents a tortured recitation of Virginia defamation law, the evidence presented at trial, and the op-ed itself. The actual evidence, however, presented during the 6-week trial before this court, which must be considered in the light most favorable to the plaintiff, Mr. Depp, is more sufficient to sustain the jury's determination that Ms. Heard's op-ed defamed Mr. Depp by innuendo. Do I want to read this whole thing? So okay. So this basically explains, I don't know, we already went through this though. This explains why the op-ed is defamatory and why it references Johnny Depp. But I guess we can just try to skim through this really quick. It's not too bad. Starting with the op-ed itself, 2 years ago, when the public became aware that Ms. Heard had accused Mr. Depp of DV, at trial, evidence of extensive press coverage concerning Ms. Heard's DA allegation against Mr. Depp in 2016, 2 years prior to the op-ed, was presented to the jury, including articles depicting Ms. Heard walking to the LA courthouse to obtain the DVTRO against Mr. Depp with a mark on her face. And we all know the infamous People magazine where she has that picture, but that picture was darkened up. It's not even the same picture as the original, if I remember correctly. Circumstantial evidence of Ms. Heard's cooperation and courage of the media break back in 2016 was also presented to the jury. Mr. Morgan Tremaine sent a team of cameras to photograph the right side of Ms. Heard's face from a news producer's tip, meaning it had been verified from a source. Additionally, evidence was presented that when the op-ed was pitched to the Washington Post, Ms. Heard's relationship and allegations against Mr. Depp were explicitly identified, and immediately after the op-ed was published, press coverage of the op-ed identified Mr. Depp as the subject of Ms. Heard's statements concerning abuse within the op-ed. It really just doesn't take a genius to connect the two. Any normal person would have been like, oh yeah, she's definitely talking about Depp. Based on the foregoing evidence, the jury could have reasonably found, and did in fact correctly found, that the 3 alleged challenge statements in the op-ed conveyed to those who read them that Mr. Depp had PA Ms. Heard during their brief marriage. A, there is sufficient evidence, including the op-ed itself, that would reasonably cause a reader to understand the headline to be about Mr. Depp. So the headline was, I spoke up against SV and face our culture's wrath. So Ms. Heard argued that because there's no evidence that she had accused Mr. Depp of SV prior to publication of the op-ed, in circumstances surrounding the publication of the op-ed, could not have reasonably caused readers to believe that the headline referred to Mr. Depp. No. Wrong. As is recognized by the very authority Ms. Heard relies upon. Like, I think a lot of people try to be very charitable towards Amber Heard, but the arguments that she was making was just not even. A lot of them were just not even like you know how sometimes when you hear an argument, you're like, oh yeah, it could happen. Yeah, that's possible. But like a lot of the defense that she had, it was just like, no, you're just making yourself look really bad right now. In evaluating defamatory meaning of the statement, it is appropriately considered in the context of surrounding circumstances and the publication as a whole. Appellates of publication must be taken as a whole, and in sense, it would be understood by the readers to whom it was addressed. Finding it inappropriate to consider each defamatory statement singularly rather than as a whole to assess defamatory meaning. The headline, thus, is appropriately read in conjunction, not just with the surrounding circumstances described supra, which is, I think, above, but also with the statements in the op-ed, including the other 2 statements the jury found to be defamatory. So they're saying the headlines, like our culture's wrath. One of these statements also state that Ms. Heard's experienced our culture's wrath 2 years ago, when she became a public figure representing DA. The headline thus can be understood by readers as referring to speaking up against SV 2 years ago. That's how I read the article as. Mr. Depp presented evidence of relevant surrounding circumstances that would reasonably cause a reader to understand the 3 statements in op-ed was conveying a defamatory implication about Mr. Depp. Okay, so I don't think we need to read this part. If there's any other jabs that we make. Oh, wait, do we talk about... Oh, I do like this part, though. Moreover, even if Ms. Heard's tortured reading of Virginia law... Who wrote this? were correct. There were contemporaneous facts presented at trial that confirmed the readers' op-ed were understanding it in context of the media coverage in 2016, namely articles published immediately after op-ed that essentially rewrote the op-ed with Mr. Depp's name. Tortured reading. I'm gonna start using words like that. It's so funny. C. Mr. Depp is not recovering for statements Ms. Heard made during the judicial proceedings. Ms. Heard's final argument, unsurprisingly, also contorts the trial evidence in Virginia defamation law. Ms. Heard appears to argue that because Ms. Heard publicly sought a DV restraining order against Mr. Depp, any further statement she makes about the A alleged in the DV Churro, or whatever, is privileged, even if such statement is not made in judicial proceeding. The judicial privilege, also referred as to absolute privilege, is not so broad. It does not apply to any statement made about facts that are subject of a judicial proceeding. We get a citation here. At trial, Mr. Depp did not even present any evidence of a statement Ms. Heard made in the judicial proceeding. He presented evidence of the media coverage surrounding Ms. Heard's allegation of A against Mr. Depp in 2016, including articles which included photographs of Ms. Heard with the purported injuries she allegedly sustained from the A. Mr. Depp did not and has never claimed that the coverage was defamatory, rather that the media coverage constituted part of the surrounding circumstances, which imbued the defamatory statements in the op-ed with a defamatory meaning with respect to Mr. Depp, namely that he, A, misheard during the relationship. For the reasons stated supra, this evidence of the circumstances surrounding the publication of defamatory statements in the op-ed could reasonably cause a reader to understand these statements refer to Ms. Heard's claim found by the jury to be false, that Mr. Depp, A, misheard. Number 8, the court, we're almost done by the way, guys. Almost done. The court should not conduct an investigation of jury number 15 because the defendant has waived such arguments and has failed to provide any evidence of unfair prejudice or any due process violation. So when I heard about the jury 15 investigation, just a little bit rundown, they said juror 15 was not born on the year that he said he was born, but his name was the same, his address was the same. Okay, what's going on here? So we don't know what happened. However, what we do find out in this document is that Amber Heard and her lawyers already knew this before the trial started. And then the fact that the verdict didn't go their way, now they're like, oh, wait a second, this guy's birthday, it's not the same birthday. But then, Johnny Depp's lawyers are like, well, y'all already knew that, and why didn't you raise that issue before? So let's read this part. A nothing burger, I like that. Ms. Heard's desperate after the fact demand for an investigation of juror 15 based on a purported error in his birth date is misplaced. As a threshold matter, Ms. Heard waived her right to challenge the accuracy of the information listed in the jury panel by failing to raise this objection contemporaneously. Quotations, it shall be sufficient that a party at all time, ruling or order of the court is made or sought, makes known to the court the action which he desires the court to take in his objection to the action of the court and the grounds thereafter. The fuck did I just what did I just read? Okay. The main purpose of the contemporaneous objection rule is to alert the trial judge to possible error so that the judge may consider the issue intelligently and take any corrective actions necessary to avoid unnecessary appeals, reversals, and mistrials. Virginia Code outlines a procedure for objecting to irregularities in jury lists and to alleged legal disabilities of jurors, provides that, I don't know if we're going to read that. As further discussed below, Ms. Heard has shown no evidence of prejudice or injunctive, and therefore her belated argument regarding jury 15 should be rejected by the court. We cite a case here, refusing to reverse case where 2 convicted felons sat on jury, a matter which was not discovered until after the trial, because defendant made no showing of injustice. Here's another citation. Finding defendant's objection to the qualification of a juror was untimely, where defendant had knowledge of the fact that the brother of a sworn juror, what the fuck, would be a material witness to the case, but did not make an objection until after the brother's testimony was not in accord with what he had hoped and thought it would be. Even if the relationship within the jury and the witnesses were a sufficient reason for disqualifying the juror, defendant with full knowledge of this relationship accepted him as a juror without objection. His objection to the qualification of the juror and his motion to discharge the jury came too late. I think that's the case in, maybe I'm getting it wrong. Let me keep reading then. Because I'm pretty sure they knew that this juror did not have the right birthday date. However, they continued with the trial anyways. Contrary to Ms. Heard's contention otherwise, the parties do have a statutory obligation to verify the accuracy of the information listed in the jury panel before trial, and any errors are not grounds for mistrial. Disregarding this clear statutory language directly on point to Ms. Heard's issue with Juror 15, Ms. Heard shamelessly presents this argument to the court. Further, the clerk's office provided a pre-panel jury list to the parties on April 6, 2022, 5 days before the jury was impaneled, which gave Ms. Heard ample time to verify the accuracy information contained therein. So they're addressing the part in Amber Heard's motion, post-trial motion. They basically said it wasn't our responsibility to check whether or not the jury is who they were. It was the court's responsibility. So basically throwing on like, I don't know, whoever works at the court that verifies it, and basically blaming like, Judge Penny, this is your court. You didn't make sure that the juror was who they say they were. So in Johnny Depp's lawyers, they're like saying, well, we are responsible for it. And the fact that you're saying you're not, the fact that you're saying that we're not responsible for it, that's BS right there, because we are responsible to verify the information. Now, here's another jab. In a rare moment of candor, Ms. Heard, and in a rare moment of candor, I'm sorry, that made me laugh so much. Okay. Ms. Heard admits that she was aware of this purported discrepancy in Jury 15's birth year from the very start of the trial. So they knew, and they didn't say anything about it. But because the verdict didn't go their way, they're like, well, actually, hold on a second. This is kind of weird. This is funky. So it's interesting. AH had a penthouse just for her clothes. Now it's TJ Maxx. Okay, I take my comment back. So TJ Maxx thing, I was trying to give her the benefit of the doubt, and I was like, because a lot of people were like, oh, the TJ Maxx thing, she's staging it, like I didn't think she staged the whole TJ Maxx thing, but now that I think about it, I was like, you know what? With everything that's like coming out right now, I think she might have staged it too, because I thought it was really weird how there's no other footage of her like entering TJ Maxx or exiting TJ Maxx or like any other footages of her from that day or like around that area, because there are people around, they know who she looks like and stuff. I just thought it was really weird that the footage was only at the TJ Maxx. So I don't know. I think it's possible, it might be possible that she got someone to film her at TJ Maxx and then they sold the video to like TMZ. I don't think TMZ was actually there. I think, they can just get someone else to film it. I'm like, okay, sell this to TMZ to show that I'm shopping at TJ Maxx. But I don't know. I honestly was trying to give her the benefit of the doubt. And I was like, yeah, I don't think I don't think it's staged. I think her and Winnie were just shopping at TJ Maxx. They were just like hanging out, sister bonding shit. And then someone saw her and decided to like videotape her and stuff. But yeah, I don't know. Now that I think about it, with all the stuff that's coming out, with the insurance, how she said she can't afford it, and how she said that the reason why she can't afford paying for the donations is because she spent it on lawyer fees. And then we find out that she didn't pay for it and that it was paid by the insurance company. So it's like all this is coming out. And now I'm just like, yeah, I think the TJ Maxx thing, I could totally believe that it could be staged now. So I don't know. TMZ don't normally stay on a TJ Maxx. But yeah. Anyways, let's continue on. So, in a rare moment of candor, Ms. Heard admits that she was aware of this purported discrepancy in Jury 15's birth year from the very start of the trial because, in quotation marks, Jury 15 was clearly born later than 1945. Ms. Heard chose not to raise this alleged discrepancy with the court during the voir dire process, which I learned is jury selection process, at any time during the 6-week trial, and thereby waived it. A motion for a mistrial is untimely and properly refused when it is made after the jury has retired. Moreover, Ms. Heard's argument is based on pure speculation. First, Ms. Heard cites to the publicly available information that Juror 15 was actually born in 1970, but they fail to attach the information to the motion and otherwise identify it for the court. Second, Ms. Heard provides no support whatsoever in her conclusory assertion that her due process was somehow compromised. While Ms. Heard has a right to an impartial jury, she has failed to identify any way in which the inclusion and the service of Juror 15, assuming arguendo, I learned that means for the sake of argument. Let me read this again. I'm confused. While Ms. Heard has a right to an impartial jury, okay, She has failed to identify any way in which the inclusion and service of Jury 15, assuming, for the sake of the argument, that there had been a mistake in his birth year, somehow robbed her of that opportunity. Unsurprisingly, Ms. Hurd cites no case law to support her argument that the service of Jury 15, if he is not the same individual that the court assigned as Jury 15, somehow comprised her due process, would warrant the drastic remedy of setting aside the verdict and ordering a new trial. I know that, like, if you lie about your questionnaire, you get effed. Scott Peterson, I think Scott Peterson is apparently getting a new trial because I don't know. Is he gonna get a new trial? I heard he was gonna get a new trial. F that person, by the way. But I heard they're getting a new trial because one of the jurors said that they've never been a victim of like DV before or something like that. But then later on, I guess 10 plus years later, they found out that she lied about that. So I think that he might get a new trial, which would be crazy because that guy is a piece of he's a piece of shit too. The reason why I gave it a little bit of credence was because I was like, Whitney doesn't I don't think Whitney makes a lot of money. She probably just makes like normal average people money. So I was like, oh, maybe Whitney was shopping at TJ Maxx and like, Amber Heard was just running errands with like Whitney or something. But yeah, I don't know. I think I'm like, yeah, TJ Maxx, it might be staged in light of everything that's going on right now. All right. Oh, do you want? So this is what I was talking about earlier, where they were like, bro, the post motion should definitely be dismissed because one, it was filed in untimely manner. It was a week after the due date, and a couple days before Johnny Depp had to reply, and then she had no access to new facts. No unfair prejudice cited. We could read this really quick, actually. Okay, so this is Johnny Depp's lawyers. Pursuant to the court's direction, Ms. Heard's deadline for submitting her post-trial, blah, 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 motions fell on July 1st. Oh, crap. No. July 1st, 2022, 1 month after the jury rendered its verdict. It is undisputed that Ms. Heard did not file her supplemental memorandum until the afternoon of July 8th. Oh, man. This is like way past the deadline. Have you guys ever had a deadline for like a homework or a project and then like you didn't talk to the teacher about it and then like days later you're just like, here you go, to see like if they would accept it? That's like basically what they did here. Here you go. Oh God, I hope that you accept it. Man, I want to see Judge Penny's face. And only fewer than the 3 days before plaintiff's deadline for submitting his opposition to the defendant's post-trial motion due on Monday, July 11th. So they submitted this on July 8th. Was that like a Thursday or Friday? Where did I pull up the calendar? Oh my God, I updated my Windows, guys. July 8th was on a Friday. And then that means Depp's attorneys had to work Friday, Saturday, Sunday in order to submit the thing by July 11th. Oh my God. I wonder if they're just like messing with them. Like, haha, you don't get your weekends off. Defendant neither notified plaintiff of a forthcoming supplemental memorandum nor sought leave of court for filing it out 1 week out of time. True to form. Oh God, I gotta learn these like scathing phrases. True to form. Because Ms. Heard filed late and without leave of court, the court should grant plaintiff motion to strike. 2. Ms. Heard had access to purported new facts months ago, so they're like, this is nothing new. In her supplemental memorandum, Ms. Heard does not, because she cannot, make any pre-offer as to why she could not have discovered the new facts until now. This is because the clerk's office provided the pre-jury list to the parties back in April 6, 2022, more than 2 months ago. In the rare moment of candor, Ms. Heard admits that she was aware of the discrepancy of Juror 15's birthday. Ms. Heard therefore concedes that she had more than enough time before the trial started and during the 6-week trial when at least 2 alternatives were available to investigate and discover the alleged new facts. Clearly, Ms. Heard waived any right to allege new facts to choose not to investigate for so long, much less to demand the extraordinary remedy of the mistrial. Damn, this law firm is so good. 3. Ms. Heard cites no unfair prejudice. Even Ms. Heard has filed her supplemental memorandum in an untimely manner, which she did not. More jabs thrown. And even had she not waived her right to raise the alleged issue by sitting on information for more than 2 months, which she did, the court should still grant plaintiff's motion to strike defendant's supplemental memorandum because Ms. Heard failed to cite any unfair prejudice. And even assuming, for the sake of argument, Ms. Heard's latest thesis that a son served instead of the father. Okay, we already read that. So, Andrew Crawford. I think he's the one that's writing these responses. Damn. He's spicy. Very spicy.